Wiretapping and electronic recording devices have become an essential part of efficient law enforcement agencies. Most of the evidence gathered in this way cannot be used by our courts to convict and punish criminals. Despite this, wiretapping equipment and other recording devices are being used throughout the nation without supervision and control to monitor conversations and obtain confidential information through illegal means. Do we need to regulate and legalize wiretapping? All America wants to know. A monthly discussion of the questions facing our country, presented in the public interest by America's favorite magazine, The Reader's Digest, in association with Freedom's Foundation at Valley Forge, and produced by Theodore Granik. This month's subject are wiretapping laws helping criminals, based on an article by Senator Kenneth Keating, Change the Law That Fosters Crime, appearing in the March Reader's Digest. To discuss this issue, we are pleased to have as our guests Senator Kenneth Keating, Republican of New York and member of the Senate Judiciary Committee; Senator John A. Caroll, Democrat of Colorado and member of the Senate Judiciary Committee; Lawrence Speiser, Washington Director of the American Civil Liberties Union; Virgil W. Peterson, Operating Director of the Chicago Crime Commission; and Frank D. O'Connor, District Attorney, Queens County, New York. We will join our group in just a moment. Now, here is your moderator, Mr. Granik.
Senator Keating, why the need for wiretapping legislation?
Well, Mr. Granik, there have been hundreds of prosecutions in New York State and in the other 4 states that allow court wiretapping, Nevada, Massachusetts, Maryland, and Oregon, which have been stymied even though the state law was completely complied with because of federal decisions saying that the use of wiretap evidence properly done under state law was still a violation of federal law and couldn't be used. The District Attorney of New York County recently had to dismiss indictments against a big narcotics ring involving sales of heroin of $500,000. In upstate New York, there was a gambling syndicate that was caught red-handed, and they had to be let go because of some of the evidence had been obtained by wiretapping. It has handcuffed the law enforcement officials of the states which have duly authorized wiretapping under court orders, and it is a menace to law enforcement in this country to get at the organized mobs.
4 state attorneys generals testified that they did not want wiretap legislation, and they thought that it would be highly injurious to the rights of privacy of the citizens. You can't keep wiretapping limited, and the price that you pay in order to get criminals isn't worth the price of loss of privacy which is involved in this.
Mr. Peterson from Chicago.
Well, I certainly think that the law enforcement agencies of this country, the prosecutors, need tools in order to cope with an ever-growing crime problem. And I certainly think that when states have, through constitutional means and through legislation, have enacted laws in their own states approving this sort of thing, that then that should be legal insofar as the federal government's concerned.
Senator Keating, you referred to your bill as a crime-tapping bill. Do you want to comment on that?
Well, I like that word better than wiretapping. The purpose of the bill is to assist the law enforcement officials in getting at the mobs and the subversives in this country. Now, one point I want to deal with that Mr. Speiser brought up. The particular legislation before us would in no way affect any state which barred wiretapping. If a particular state does not want to have prosecutions based in any degree on wiretapping, that's their business. The bill which is along the legislative path in the Congress is one which will say to a state, if you have a state law which permits you to intercept communications and you comply with the provisions of a court order and you require the telephone be identified and the person to be whose phone is to be tapped be identified, and that you go to a court and show there's probable cause that a crime has been or will be committed, and you only have it on for 60 days and you can only extend it 30 days, and you make reports to the Department of Justice periodically on what you're doing with all of those safeguards. If a state then wants to do it, then certainly I don't think that their prosecuting attorney ought to be sent to jail, as has been suggested by one of the federal judges, because he is complying with the state law.
Now, Mr. Granik, may I say
ahead,
now, I'm also a member of the Constitutional Rights Committee, the Senate Judiciary Committee, and I think Senator Keating's bill, if I remember it, does do what he says. It gives those states a right to intercept by wiretapping, and those that don't want it do not have to do it. But we're not confronted with that alone. And this is the point I want to raise this evening. We now have a bill involving federal legislation which gives the federal governments the right now to intercept messages, wire messages. It also does this, it gives every state the right to do so, whether they have passed state legislation or not. And they have legalized this, I think, in my opinion. I haven't reached the final judgment on it. I think this is a most serious situation. Now, I've asked a little while ago Mr. O'Connor. I don't think it was on this program. It is true that 20 years New York has had this experience, it's my understanding, with wiretap legislation. That is, it's been legal in the state of New York. This has been knocked out by the federal courts.
Let me hear from Mr. O'Connor.
Am I not right in that?
Yes, you're entirely right, Senator. It has been knocked out, but the point I'd like to bring out at this time, and I think it's terribly important, that in the 20 years that we have been using wiretaps according to the Constitution and laws of our state, there has never been a single complaint by anyone of any abuse of the privilege by any district attorney, which I think is a tremendous thing.
But there may not have been any complaints about abuses by district attorneys, but there have been complaints about abuses by policemen and about other individuals, by private individuals.
There you are, and I think you should tighten up on that part of it just as much as possible. Illegal wiretapping has been prosecuted in New York State. There have been actual convictions, and it's a criminal offense to engage in illegal wiretapping.
It's a felony.
It's a felony. And in most states that's true. And I would entirely agree with you that as to illegal wiretapping, you should crack down on them just as hard as you can.
But under the present federal law, where it is a crime to intercept and divulge, which was the reason for knocking out the New York constitutional provision, in effect, anyone who is tapped has violated the federal law. There has never been a single prosecution of a law enforcement officer who has tapped without a court order, for example, in New York, or in states where they don't provide for court orders. They have prosecuted where there has been attempts at extortion, where there's been blackmail, where there's been misuse. But for officers in line of their attempt to obtain evidence for prosecution purposes, there has never been a single prosecution of a law enforcement officer. Now, if your bill is passed, what guarantee is there that you are going to prosecute people who then tap outside the limits of the law? The practice in the past has not been anything to give us that indication.
The state laws provide for prosecution, and there were in Brooklyn 2 police officers.
Well, I think, Senator, if I could interject there for a moment as the only prosecuting officer on the panel.
Former president of the New York State District Attorneys Association.
Let me say this very, very emphatically, that we do not get complaints of illegal wiretapping in New York State against policemen at all. The only times it has occurred have been 2 or 3 times in the last 2 or 3 years, and every single one of them have been diligently prosecuted.
If I may ask,
Senator Caroll,
I think I'd like to clarify the issue in my own mind. When we're talking about wiretap, what are we talking about? We're talking about tapping in on telephone conversations, both private and public, in the home, public booth, or wherever it is. This is a tapping process. Now, the tapping goes on today in the federal government. This is the testimony before our committee. The FBI taps in on very important cases, kidnapping, subversion, but the difficulty is they cannot use that testimony in court. Now, this raises a very basic issue. In New York, they could introduce that in court. As a result of a federal court decision, they may tap in, but they cannot use it. They cannot divulge. They cannot reveal, and they can't use it as evidence. This is the basic issue. I'm not speaking about New York.
I understand that,
I
Senator, but
come
don't you
back
think...
again to the federal government, if I may. Pardon me, Mr.
No, quite all right, Senator. I interrupted you.
I don't want
Well, I
to
was going to
interrupt
say,
you.
don't you think that now is a good time to put this entire problem under strict supervision? Don't you think it's about time that we did pass a bill similar to Senator Keating's bill, where any federal officer who violated the law, who tapped wires in violation of the law, would be prosecuted?
But Senator Keating's bill applies to the states.
The
The federal
it applies
government
to
bill
both federal and
applies to...
state.
No, there are two
No,
problems.
Senator
here.
Keating.
There are two problems. One is the very limited bill, which I have introduced, and as Senator Caroll knows, is now pending before the full committee on the Judiciary. And that just says that in these 5 states which have permit wiretapping by court order, if they comply with their state law, plus additional provisions which I've already outlined, which are written in for the protection of the citizen, then they may use that evidence in court. Now, there is the broader bill, which Senator Caroll has referred to, which the Attorney General has now sent up to us, which does get into the tapping in both the federal and state courts. Now, one difficulty that I see on the one side, and this will appeal, I think, to Mr. Speiser with the Attorney General's bill, is that in certain classes of cases, he would permit wiretapping without any court order in the federal court, simply on the authority of the Attorney General. One man would determine whether tapping could take place. Now, the bill is going
appeal, ironically.
the bill is going to meet objection on that side. It meets objection on another side from the fact that when it attempts to deal with the state wiretapping, it does not include the 3 offenses, liquor, prostitution, and gambling, where all of the evidence shows that most of the mob have moved in. Now, Frank O'Connor, former president of the New York State Association of District Attorneys and a distinguished prosecutor, can speak with much more authority than I can on this.
Mr.
In other words,
Speiser,
you want to extend that to liquor, to gambling, to racketeering, if this would be in the state law of New York.
In this,
Yes.
Yeah,
yes.
but this would not be in the federal statute.
This, in the Attorney General's bill, he does allow it in those areas if the prosecution is in the federal court. But in setting up the permission to tap wires in state court, in the states, he does not include those 3 important offenses where I'm sure Frank O'Connor would agree the mob are usually engaged.
Mr.
Let me-
Speiser,
let me
may I
take
just
on-
ask one question? In the Digest article, Senator Keating says his bill contains practical safeguards against abuse. Do you think there are?
No. Let me take on this question of the protections of court orders. A court order has been analogized to a search warrant. In a search warrant, you get a warrant, you go into a person's home, you look for particular articles, you go in, you come out, and the person knows about it. With a court order in this particular situation, the individual whose phone is being tapped doesn't know about it. They aren't looking for a particular item. They will hear everything that comes over the wire. There have been taps which have been obtained in New York City in which anyone who uses a public telephone has had their conversations heard. And it covers conversations between a husband and wife, between an attorney and client, between a doctor and patient. There is no practical way of limiting your information that you get from a wiretap with a court order. I don't think the analogy is a good one. I don't think it applies.
Well, if I may,
Senator Keating.
I think I should let Frank O'Connor say more because he knows this subject.
You're doing very well, Senator.
May we hear from Mr. Peterson from
right.
Chicago?
Well, there is no question but what the organized criminal gangs today are utilizing interstate communication system tremendously, extensively in connection with the commission of all kinds of rackets and crimes. Now, in many instances, it's virtually impossible for duly constituted law enforcement agencies to deal with these problems unless they have some tools with which they can properly deal with them. Now, the question is always raised whenever you try to place in the hands of law enforcement some additional tools with which they can cope with a problem. The thing is always, there's always a red herring brought across the floor that there will be abuses.
certainly everybody on this panel, and certainly everybody that I know in law enforcement, are gravely concerned over the protection of individual rights. Where we become completely divergent views is when we consider whether or not, in the protection of individual rights, we are doing it at a disproportionate loss to the rights of society.
That's the
Right.
point.
And to me, that's the basic issue.
Frank O'Connor and I have been fighters for civil liberties and civil rights for years, but the law-abiding citizens of this country have some rights to be protected from criminals also.
And it's a button.
And as Mr. Speiser, he referred to searching a man's home. I don't see any difference. You can go to a court and get a court order to search a man's home. You can go and get one to search his pants pocket. Now, certainly, if you show the same kind of evidence, you ought to be able to go to get an order to intercept his communication over the telephone.
But he knows you're searching his home. He knows you're searching his pocket. He can go into court and try and quash the evidence that was obtained by this. But when you tap a person's phone or a public telephone, he doesn't know who is listening.
If he isn't a criminal and hasn't committed a criminal offense, he doesn't have a thing to worry
Senator
about.
Keating,
Senator Keating, one at a time. Mr.
Senator
Speiser, go ahead.
Keating, you probably say things over your telephone that you would prefer not to have other people know about.
I don't expect him to get an order on me.
Okay.
I don't think we would.
I know, but the thing is that you may not know when you make a phone call or someone calls you whether there is a tap on that wire. You may not have initiated it. It may not be on your phone. But if you call New York from the District of Columbia, where they have had a court order law in New York, you don't know whether the phone that you made a call to is tapped.
I will concede that in many instances where wires are tapped, the persons whose wires are tapped may not know it. But let me say this to you, that any DA who has projected the proper image of himself as being alert and conscious and who cares about civil liberties will very quickly get complaints of all kinds. We get them against cops, we get them against people who are doing wrong things. Over 20 years, if there has been illegal wiretapping by law enforcement officials, we would have gotten complaints. We've never gotten one.
Well,
Mr. Speiser, go ahead.
there was the one instance of law enforcement officers who were engaged in wiretapping for private gain. Now, you did have prosecutions.
And they were diligently prosecuted.
I know, but you don't have, but because you don't have complaints of law enforcement officers, I'm not talking about DAs, I'm talking about police officials, doesn't mean that it isn't going on.
But we have another basic question here, the right of privacy of individuals, which is a basic constitutional question because it involves the liberty, one of the few liberties left to the people. And this is why I think the Supreme Court will handle this matter. Senator Keating knows this. We'll be handling the Kennedy bill, the Bob Kennedy bill, and his bill in committee. We'll thrash it out. We'll try to come out with some sort of a bill, I hope. I think his bill is far less comprehensive than the administration bill because I'm afraid I repeat this once more and I'm done with it. Once they asked to tap a telephone wire because of certain federal crimes, the next time, maybe 10 years from now, they'll ask for the electronic device like you have
Right
in
there.
New York.
Senator Keating, what about other recording devices which are used for monitoring conversations, such as briefcases with a hidden microphone in the handle, or a wristwatch recording instrument capable of picking up conversations, or a harmless-looking tie clasp, which is also a highly effective recording device? Should we also legalize these devices, Senator Keating?
Well, that, Mr. Granik, gets into an entirely different field from wiretapping. That's what's called eavesdropping, the use of electronic devices. I happen to have a bill, as Frank O'Connor said a few moments ago, we'll be here all night if we get on this subject. I happen to have a bill to tighten up on those devices. No, my answer is no to your question, whether that the same should apply to them as to wiretapping. My bill is very comprehensive on that subject. I think that's got to have a lot of study, and I'll say this, any wiretapping legislation is really a stopgap because these devices to which you've referred are being used more and more, and I must stress with all the strength I can that this wiretapping legislation has nothing whatever to do with the use of these devices.
Senator
Mr.
Caroll.
Granik, may I say, it may not have now, but it was not so long ago when we had testimony before our committee. Think of this, the government of the United States saying that because a spike was put only halfway into the wall, it was not a trespass, and therefore not a violation of the constitutional rights of this individual. How easy it'll be to take the next step. And this is what I'm concerned, why I raise basic constitutional questions dealing with the right of privacy, which is basic to our whole
Senator
system of
Caroll,
government.
those were court decisions. Those were court decisions. And we can't interfere with them. What I'm saying is that this legislation, or any legislation indeed relating to wiretapping, even if it's more comprehensive than the bill I've offered, any of that legislation has nothing whatever to do with the use of other electronic devices.
I'd only say to you that I'm sorry the decision never came up to interfere with New York.
Mr. District
To
Attorney.
interfere with New York. I'd like to see New York run its own show. But when I see the way that this is spreading over the country, I'm very apprehensive, although I have not made up my mind finally. I have some strong feelings, as Senator Kennedy knows, on this subject.
Senator Keating, in his Digest article, quoted District Attorney Hogan, your colleague in New York, as stating that wiretapping is the single most valuable weapon in the fight against organized crime. Would you agree with that, Mr. District Attorney?
Well, I don't think there's any question about it that the use of wiretapping under court supervision is a very, very valuable weapon in the hands of a competent modern district attorney. There's one thing I want to point out, and I think it's terribly important, because there's a great deal of public concern about the use of wiretapping, and there was a book written a few years ago that gave the outlandish, and I say totally outlandish, figure of between 16 and 29,000 wiretaps in New York City alone. Now, I just want to put this across very forcefully, that our District Attorneys Association of the state of New York made a very careful and accurate and scientific survey of the number of wiretaps used in the entire state of New York. They do not exceed 500 for the whole total year.
I think Mr. Speiser wants a word here.
Could I add a word on what
Senator Keating.
Frank Hogan said in this testimony, because I think this is
Surely,
important.
go ahead, Senator.
He said, and I quote him, "I do not think our office could have convicted Charles Lucky Luciano, Jimmy Hines, Louis Lepke Buchalter, Jacob Gura Shapiro, Joseph Sox Lanza, George Scalisi, Frank Erickson, John Dio Guardia, and Frank Carbo. Now, if there was ever a who's who of gangsters, it's that crowd."
right.
And he says he never could have convicted them, and Frank Hogan, like Frank O'Connor, is a distinguished district attorney, had he not had this weapon in his hand.
But
Mr. Speiser wants a word.
Yet these are an infinitesimal number compared to the total number of crimes that are charged.
Mr. Peter,
And then secondly, you say that they're only used in major crimes. They are generally used in prostitution, they're used in gambling, they're used in vice crimes of that kind. That is their general basic use.
They are
get away
used,
just for Mr. Peterson.
That is crimes where the gang has moved in,
right,
where the
the
organized mob is
crime,
operating.
organized
The
crime.
very lifeblood of organized crime is gambling, prostitution, and that sort of thing. The figures show, according to their experience in New York, that there hasn't been no abuses of it. But let me tell you this, you're talking about an infinitesimal number of cases. The conviction of a Jimmy Hines or a Charles Lucky Luciano from the standpoint of dealing with the overall crime problem is concerned is far more important than the conviction of 1,000 of your run-of-the-mill cases.
You don't pass laws in order to get a Jimmy Hines. You pass laws in order to handle the situation. But let me raise this
I'm sorry. Our time is up. We'll return after this important announcement. Thank you very much, Senator Kenneth Keating, Republican of New York, for being our guest on All America Wants to Know. And thanks to our distinguished panel for a most interesting discussion. Senator John A. Caroll, Democrat of Colorado. Lawrence Speiser, Washington Director of the American Civil Liberties Union. Virgil W. Peterson, Operating Director of the Chicago Crime Commission. And Frank D. O'Connor, District Attorney of Queens County, New York. Now join us again next month when All America Wants to Know will present a discussion entitled, How Can We Meet the Common Market Challenge? Based on an article by Bruce Hutchinson, appearing in the April issue of the Reader's Digest, the world's most widely read magazine. And now, this is Theodore Granik bidding you goodbye.
All America Wants to Know, a monthly discussion of the great questions facing our country, is presented as a public service by the Reader's Digest in association with the Freedoms Foundation at Valley Forge. America Wants to Know. Created and produced by Theodore Granik. Associate producer, Julian A. Bartolini. Directed by Dennis B. Kane. Senior technician, Richard Pfister. This is Julian Barber, inviting you to be with us again next month when a group of citizens will debate how can we meet the common market challenge, based on an article by Bruce Hutchison, appearing in the April issue of the Reader's Digest, the world's most widely read magazine.